That's why I said the arrows are very important for the constituencies. Now, the Commission has not internalized that fact to the extent that it wants to start redrawing the boundaries of the Constitution. Because we're talking about Constitution here, not the Elections Act. Now, if you have a referee who wants to decide on the rules of engagement, he has a problem with the rules that have been given to him by the people of Kenya, then that is a problem. You cannot, as a referee, once the parties have given you the rules of engagement, you cannot be the one who now starts to decide which one is favorable and which one is not. That is not your discussion. That's a discussion for Parliament and the people of Kenya. And they've told you in the Constitution what that is. I would expect some other person to file this appeal, but not the Commission. If the Commission has taken such a strong public position on such a point, my question is this. Assuming, and I hope it will happen this way, the Court of Appeal upholds the decision of the High Court. Will the Commission implement that decision? It is setting up itself for public ridicule. You cannot be litigating on interpretation and challenging, taking a strong position on a law that the Commission will be required to implement. There will be half-hearted implementation of that law when the Court of Appeal will have decided on this particular matter. And you don't want to do that in the run-up to an electoral process that is major as the one we are approaching. On the question of political party primaries, we've seen the disputes that arose. At least for the first time, political parties were slightly better organized in terms of their own dispute resolution process. There was a semblance of an IDRM within the political parties. The political parties tribunal is dealing with some of the disputes. The only challenge we have is based on the timelines that we have. Some of those disputes may spill over into the High Court, and you may end up having a situation where orders will still be issued from the courts so late in the day that ballot papers may not be printed bearing the names that those orders will have given. So that is a challenge. Probably we should have moved our party primaries as early as even January or last year in December, so that you have sufficient time to deal with all disputes that may arise from these disputes. So we run a challenge where the Commission will run out of time, courts we may make orders, that orders which because of the 8th of August may not be implemented in time. So we may elect someone who immediately is elected. You have a petition to remove him because he was elected as a result of a process that ignored a court order. In a nutshell, is it all gloomy? It is not all gloomy, but it is gloomy. If we start having a national conversation on how to address some of these challenges, we can still have credible, free, and fair elections. And the opportunity to dialogue is still open. I do believe the Commission should start having a more proactive public engagement with stakeholders in the electoral process. They must recognize that their role in elections is a referee. The players determine the rules and the modes of engagement. We should be having this kind of conversation with the media, with the civil society groups, with political parties, faith group-based organizations, so that we have a level playing field, that everybody will respect the outcome of that process. We should not allow the Commission to run an opaque electoral process that will give rise to legitimate concerns from disenfranchised political parties or candidates to reject the outcome of that process. Thank you all very much, and I wish you all the best.